In this section, we'll apply the 3 key legal infrastructure tools, contracts, insurance, and entity, to the protection of intangible assets. Intangible assets include your intellectual property, such as trademarks, copyrights, and patents, as well as trade secrets and confidential information. They don't appear on your financial statements, but they increase the value of your business through brand recognition and competitive positioning in the marketplace. Many business owners are aware that they have intangible assets, but aren't proactive in protecting them and don't know when they are at risk. So let's apply the 3 legal infrastructure tools to intangible assets. A number of common contract terms are essential to protection of these assets. You want to look out for these in all the contracts you sign. The first is confidentiality. You should require anyone receiving information about your business to sign a contract with confidentiality provisions. A second key term defines the ownership of any intellectual property created. By default, the person creating the intellectual property owns it under copyright law, even if you paid for it. Your contracts must specify this work as, quote, a work made for hire, and explicitly assign it to you. Third, consider relationships where you allow other parties to use your intellectual property. Maybe you allow a referral partner to use your templates or training in their business, or someone to use your brand on their website. These are your intangible assets, and you want to control or limit their use of these assets. These are just a few terms that reaffirm why written contracts are essential, even what would be seen as simple relationships. They offer clarity, but they also ensure your intellectual assets are properly controlled for your company's long-term value. Insurance doesn't have a significant role in protecting intangible assets. Some policies may allow a business to make a claim for the misuse or disclosure of assets as a theft of confidential information by employees or third parties, but this can be pretty hard to prove. The entity in this case provides you the repository for holding the intangible assets. When you have high-value intangibles or intangibles that are used across multiple businesses, it may be beneficial for those to reside in an entity separate from the operating business. This insulates them from creditors and allows flexibility in their use. You should also protect your intellectual property wherever possible with federal and state registrations. These would typically be trademarks, copyrights, and patents, which can be protected through registration through the USPTO or Copyright Office, and provide evidence, if needed, of your claim to the intellectual property. Intangible assets differentiate you from your competitors and build value for your business, but they require proactive steps using contracts and registrations to protect this value for your business's future. Let's look at your intangible assets and the tools for protecting it in Section 8 of the workbook.